likelihood.
No, ये बात आपकी sorry doesn't hold any water. Let's read first disqualification. He is a citizen of Pakistan. Suppose Mr. James Gray from America comes and contests, born American citizens, never been a Pakistani citizen, and gets elected. Please wait. Now go to 63(1)(c). He ceases to be a citizen of Pakistan. That is, a person was a citizen of Pakistan, has now taken on citizenship of America. So you are saying, yes, once that somehow Mr. James Gray got elected, you can't touch him now. ये sorry to say, ये आप ऐसा distinction not draw करें.
I am not saying this.
Mr. Khurram, there's one way of looking at it. Just read the first line of 62 and the first line of 63. It will show to you that it's interchangeable. There is hardly any difference. A person shall not
be qualified
to be elected. रुक जाएं. आप 63 पढ़ें.
A person shall be disqualified
from being
person
elected.
Shall be disqualified
From being elected. So
From
both
being
are
elected.
happening before the election has taken place.
Elected
The
or
word is-
chosen.
हाँ.
वही बात है.
दोनों चीजें एक है.
फर्क नहीं पड़ना.
Disqualified or qualified है, but it's synonymous. I mean, it makes no
मतलब
difference.
63 का जो second
तो फर्क क्या पड़ना है इस argument से आपके? How will it support you?
So because if I can convince my lordships that they are two distinct sections because of their
Because there are two distinct sections, but what will turn on it? ये बताएं ना.
then we have to interpret 62(1)(f only.
तो वही उसी पे तो आप हमको ले जा
And
रहे
we
हो.
do not have to interpret 62(1)(f in view of 63(1)(h.
चलें 62(1)(f) को कर लेना फिर आप.
आपका आर्ग्यूमेंट ये है कि 62 and 63 are distinct articles and we cannot interchangeably read them to give them a meaning.
My lord.
So उनको separate पढ़ेंगे, उनको separate. We've understood your point.
आगे बढ़ें. थोड़ा सा स्पीड कर ले फिर. We don't want to leave this case unresolved.
10-15 more minutes. Now, when I distinguish that they are two distinct, then we have to read 62(1)(f) on its own. Every word has to be given its meaning.
चले थोड़ा जल्दी करें.
Mission is that when we will read 62, then as long as the declaration by a court of law is in field, disqualification will remain.
तो उधर ही
Court of law declaration is the Supreme Court itself. ये point पे आ जाइए ना.
Supreme Court itself cannot give in any other jurisdiction other than in its appellate jurisdiction
हो गया
from
ना
the election
आपके
tribunal.
चलो अच्छा ठीक
आपका
है.
फिर समीउल्लाह बलोच वाला आर्ग्यूमेंट है ना कि once the declaration is there, 62(1)(f) has to be read alone. Once the declaration stands, disqualification stands.
My lord.
And it goes on as long as the disqualification. So the question to you is that you have to look at the Constitution in totality as a whole. Does it not appear odd to you that for other crimes as big as perhaps treason in G and others, you can always come back and contest election? It's not a lifetime situation. But for a civil wrong, which could be as small as committing a misdemeanor of misdeclaration or just lying through you've omitted one entry in a return, the punishment in a way is for life. But if I were to go murder somebody, if I would commit treason, if I would do kidnapping, I could come back and contest election.
Where from the tribunal gets the powers for life time disqualification?
It has declared.
No, where from gets the powers to declare him
Has
for life?
declared a decree given remains intact for all purposes.
Fair enough, we've understood that.
आगे बढ़ें. चलें, next point.
Now this argument basically it lies in Islamic principles. If you look at PPC, out of all those offences, there are very few offences in which mens rea is dishonesty. My submission is wherever mens rea is dishonesty, we are talking about public office holder
जो आपने you just very casually referred to Islam, either back it up because I completely disagree with you. You have to back it up. If your contention is agreed, there were those who were violently opposed to Islam, and then they became Khalifs, Khulafai Rashideen. तो वो आ ही नहीं सकते थे फिर वापस. This just don't throw in Islam just like that. It is contrary to Islamic injunctions. तौबा का प्रिंसिपल है, राय रास्त पे प्रिंसिपल वापस आने का प्रिंसिपल है, मुस्तकीम शारे मुस्तकीम पे वापस आने का प्रिंसिपल है. ऑल शुरू में तो 2-4 ही मुसलमान थे.
I mean, we are.
तो ये आप ऐसे just don't throw in Islam to give it a validity.
No, my lord. What I am submitting is, if repentance or tawbah, when we look at it,
रिपेंटेंस और तौबा की तो बात से आगे मैं चला गया हूँ.
so that's what I am submitting. These are 3 things kept by God to Himself. Number 1,
Not at all.
Izzat Zillat.
Not at all.
Let me make my submission.
No submission. You refer to the Holy Quran. You can't just make a submission like this. ऐसे नहीं होगा.
Could I change the subject a little? Let me just introduce one other aspect. Let's stay on 62(1)(f). If you look at 62, some of the disqualifications or qualifications are mentioned in the Constitution itself, like he has to be a citizen, the age and all. This is specifically provided. 62(1)(f) brings in a disqualification from a declaration from another court under some law, not the Constitution. It is a declaration of disqualification under declaration of contrary under some law. And if the law Parliament goes ahead and fixes that law and says any such declaration of that law has to be for 5 years, that is actually not tampering with the Constitution. It is providing that that any declaration in 62(1)(f) is arising out of a law, not of the Constitution. Because court of law ne karni hai na disqualification. That disqualification is arising out of a law, and the Parliament goes ahead and says any disqualification under the law has to be for 5 years. So then, with that 5 years amendment brought in, isn't the period being provided for 62(1)(f)? Because the Constitution itself doesn't give an unlimited period. It is relying on a declaration coming out of a law, and law has been corrected and given a period. So there's a distinction. Had there been a constitutional provision, disqualification like age being 25, then perhaps, to my mind, legislation could not do it through ordinary legislation. Constitutional amendment was required. But in this case, the declaration emanates from the law itself. So law is being given a certain time frame. Is pe kuch roshni dal?
My lord, it depends on the validity of the law. That's why I tried to argue that under what proceedings we are before my lordships. I rely on PLD 2012 Supreme Court 923, Baz Muhammad Kakar Federation of Pakistan. It is the case where Contempt of Court Act 2012.
हमने सारा आर्गुमेंट सुना हुआ है. प्रोपोजिशन बता देना प्लीज.
My proposition is through ordinary law, Parliament cannot amend the Constitution.
No, fair enough.
It has not amended the
That's what I'm trying to tell you.
Added in the Constitution, because how do I demonstrate that
Whether the court can amend the Constitution,
court can interpret it?
interpret in a manner to amend the Constitution or to
No, my
read
lord.
into the
No, my
Constitution.
lord.
So this is what we are asking from you, whether the interpretation can be done. देखिए इसमें एक बात आप ये आप कह रहे हैं 62(1)(f) में ये बताया गया है कि डिक्लेरेशन होनी चाहिए कोर्ट से, और आपने कहा कि डिक्लेरेशन सिर्फ ट्राइब्यूनल दे सकता है. ट्राइब्यूनल अंडर सेक्शन 157 वो ग्राउंड्स बताए गए. ठीक, क्या उन ग्राउंड्स में ये बात है कि ट्राइब्यूनल इस बात पे आपको डिस्क्वालीफाई कर सकता है कि आप राइटियस नहीं हो, आपको सजेस्ट नहीं हो, आप अमीन नहीं हो, आप सादिक नहीं हो? ऐसी डिक्लेरेशन आएगी तो 162(1)(f) इस्तेमाल होगा, अदरवाइज नहीं होगा.
That's what I'm saying.